Welcome to this talk on intellectual property basics and sticking points for negotiating research agreements. As you see, this is rather dated at the time of recording. This is just about the same time in October, a week or so ahead, but in 2009. Still, the basics of this will not have changed. This was a presentation that I attended back in '06. By Bethlyn Maxwell, with having a PhD and a JD of the University of Texas System, the Office of General Counsel, the OGC. So the UT System OGC has oversight on all the public institutions under the UT System, and they are very powerful, and you can get to their website through the UT System and see what updates there may be, but certainly there's enough in here that it will get you on track and to help you understand this aspect of science and education. So the discussion points will be patent law as a primer, and then 4 major areas of negotiation and research contracts with industrial partners. Intellectual property, so some troublesome clauses in research contracts are part of what we might see. Confidentiality, publication, and indemnification. So quite obviously I'm giving someone else's talk with their permission. I did get permission back in 2006, and it stands today. They just never made the recording available, so I'm finally doing it myself. So as a patent law primer, we think of the types of intellectual property. There are trademarks, and what the trademark will do is it identifies the source of goods or services. Copyrights protect works fixed in a medium. And these are basic definitions. You can see more detailed definitions. Actually, the U.S. Trade and Patent Office, USTPO, you can search that. It's www.utsp USTPO.gov, and you can go to that site, and all these details are there. It's a tremendous resource to improve your background in this area if you need more than what we're just introducing here. Trade secrets, best where the subject matter can't be readily reversed engineered. But of course, an important thing here related to trade secret is the non-disclosure agreement. So if you're working in a setting where IP is being used or developed, you're very likely, even as a trainee, as a student, to be asked to sign a non-disclosure agreement, possibly with the company with which the contractor's work is being done, or with the university itself, because the university is owns the IP, or will own. And then patents, there's 3 kinds: design, plant, and utility. And again, for additional details, although we'll look at some, you can look at the USTPO. So the government-sponsored monopoly is a sense of what the U.S. Patent system is. It's limited by time and geography, so a patent in the U.S. is not a worldwide protection. There's no such thing as a true international patent. You have to go through a certain mechanism to get protection in each foreign country. So it's an extreme challenge. Some of the rules and laws differ. So if you think you're going to get into this area of IP, you need to become more familiar with them and talk to the technology transfer office at your institution. Get to them as soon as you can, as early as you can. There's such a thing as an invention disclosure form, and you can start one at any time when you first have an idea. So it does not convey affirmative right. It's just the right to exclude others. So it doesn't give you the right to just push this on the market, but what it does do is protect you from anyone else using it. So Article 1 of the Constitution provides the legal foundation for this, and it's administered by the Commerce Department through the USPTO. I kept saying TPO, didn't I? USPTO, Patent and Trademark Office. So the requirements for securing a patent in the U.S., there's a statutory subject matter by category, and I'd recommend that you go to the Patent and Trade Office to read about this more. It's a very important aspect of this. Just following up with the word category isn't sufficient. Novelty, so new or the first to invent. Utility, specific, substantial, and credible use. This is one of the easiest to establish for something, an invention, to be considered as patentable. Non-obvious or not obvious, so a person of ordinary skill in the art would not just do this on their own without being prompted or inspired. This is a little more challenging to establish than utility. The written description part is extremely challenging, clear and concise terms, and inclusive as well. So to have it be as broadly inclusive as reasonably possible, so that you maximize the protection. The enablement enables others to make and use. So it has to be possible for others to do it. So the patent, this written description, would be in the sense of directing someone on exactly how to do it. So that's how it links with the enablement. And best mode, some way to carry out the invention. So another way of thinking about this is a term that's used is called reduction to practice. So can it be implemented? So what is patentable subject matter? So a novel subject matter, new, not made or done before. So you have to show that it is new. You have to put in some work yourself, and then later the patent lawyers follow up and finish it off and make it official. What is an invention? A process, machine, manufacture, composition, or improvement. There have been some recent, again, this is 2009 at the time of recording, so in the past 3 years there have been some changes. One of the biggest changes that has occurred is that it's going to become very difficult to get a diagnostic test patented. And so at present there's a lot of controversy about this, and everyone's waiting for it to change. So change back the way, to stay the way it is and not to change. So it's important to stay on top of what is going on, and of course interfacing with the Technology Transfer Office is the best way, because that's their job to stay well informed and updated on exactly what the present status is. So you cannot claim products of nature. So a biological phenomenon cannot be claimed as a patentable material. Physical and chemical principles either. So under utility, it's the usefulness of an invention. So there has to be a specific utility. So is the utility specific for the claimed invention? So these are phrases that you'll be hit with if you get into this arena, and you'll be saying, what in the heck are you talking about, and what do you really mean? And it really means that you have to show exact uses of exactly what you are claiming, and so that's why it's good to go and read some patents to see that it's a series of claims that put things into a series of steps, sequences in a procedure or something like that. And then you begin to see how this makes sense, that typically what is the overarching claim within an invention is multi-staged, and so to have it be clearly with a specific utility, associated with a specific utility, is challenging if you're having to do the initial writing, and typically that is the case, because no one's going to know it quite as well as you. The credible utility is that specific utility easily recognized as something of need and easily, readily accomplished, at least. Not necessarily easily, but things exist to accomplish it. Substantial utility, so does it have real world value? In other words, will it make money, or can it benefit people or animals? Specific utility, again, the utility has to be specific to the subject matter claimed, as we had said. So, if it's biological, it should have biologic specificity. The contrast to this, you contrast this to a general utility that would apply to the general class of the invention. So is it computer-dependent software package that is going to accomplish something in the arena of biology? So it crosses from general to specific, and it has to be obvious how they link and interplay and are interdependent if necessary. Under credible utility, then, the standard is whether a person of ordinary skill in the art would accept that the disclosed invention is currently available for use, for such use. Perpetual motion machines are just not believable. It's never going to happen. It cannot happen. Too many forces work against it to have it be considered even possible. But some nucleic acids might be used as probes, chromosome markers or forensic or diagnostic markers. So these are obviously credible. People could recognize them and say, oh yeah, that makes sense. I could see how that would be used, how it would be possible even. Substantial utility, the real world use, so you have to fit it into the present needs of the society, recognizing markets, competitors, and how you are going to have a competitive edge, what is novel about your contribution versus what exists. So you have to know the present state of the art in order to give such information to answer these types of questions. So it must not require further research to identify or confirm a real-world context. It has to be established at the time that the patent application is submitted. There is such a thing as a provisional application that doesn't require all of this level of confirmation, but within a year of submitting the provisional application, you have to have the full patent application submitted. If you don't have it by then, you're probably out of luck forever. So you throw away the throwaway utilities are not substantial uses unless nature of the invention is specifically directed to such useless uses, right? That the dispensability would be part of it. The invention cannot be anticipated, so not anticipated by the prior art. This is really, really challenging. How did it occur to you if it would not have been anticipated as the next step obvious to anyone else? So the applicants shall be entitled to a patent unless one of the 6 conditions creates a time bar, or if the applicant is not an inventor. So there are certain criteria for be considering an inventor or co-inventor. It's not the same as being a collaborator. Again, so you need to discuss this with technology transfer offices or read up on it yourself, both, most likely, to understand this. I don't recall exactly if we're going to get through those 6 conditions, but anyway, each and every element of the claimed invention must not be disclosed in a prior art reference. So you can see that there is a strict process which must be followed by the tech transfer people when you go to their office with your invention disclosure, for them to determine initially whether they would believe that it is patentable invention before it would ever get to the Patent and Trade Office. The objective standard of someone skilled in the art of the invention, it has to be considered as well. So would it be not too far of an extension of the imagination in the factual world of factual evidence to envision what was invented. So the invention cannot be obvious. An invention is not patentable if the subject matter of the patent claims as a whole would have been obvious at the time of the invention was made to a person having ordinary skill in the art to which the claimed subject matter pertains. So this is the type of wording that you encounter, and it is the onus is placed upon you to prove this for yourself, and you get some help from other people, but you become the expert at this point, and you have to come up with the information to say, no, this is how I view it from the perspective of others. This has been the experience, and the experts that I'm able to assess and make any predictions on show no signs, no evidence of moving in this direction. So the factors to be considered: educational level of the inventor, type of problems encountered in the art, any prior art solutions to those problems, rapidity with which innovations are made, sophistication of the technology, and educational level of the workers active in the field. So quite obviously, in our arena, we're talking about people with PhDs, certainly bachelor's, master's, and on up, having sufficient scientific education and training and expertise to deal with the matters that would most likely be in one of our inventions. So the enablement requirements teach how to make and use. So the written description has to be full, clear, concise, and exact terms. So this is why I say go to the U.S. Patent and Trade Office website, search for a patent in your area, and read it. It may take you a long time, but read as much of it as you possibly can. Get to understand each piece and part of it. The enablement must enable others to make and use the invention without undue experimentation. And the best mode must present the best way to carry out the invention. So you have to reveal everything, but without revealing everything. And I know that sounds bizarre, but that's basically the way that you will be told to write it, and that the attorneys will put it together ultimately so that it meets these, but it doesn't necessarily put absolutely everything into the hands of the reader. So you give them enough so they could do it, and it's almost everything. Anyway, don't let my terms mislead you into thinking that you're withholding things there. You have to discuss it with the tech transfer and patent attorneys to understand the nature of that type of written communication. So non-infringement patent disputes, the inventorship disputes become rather tricky. Defining inventorship is difficult, but it is clear-cut enough, and there are approaches where people are interviewed by someone that is very familiar with the invention, typically from the invention disclosure, and they can quite readily tell who was involved in coming up with the original idea and who wasn't. So it's tricky. You need to come to understand this before you enter into a deal with someone and say, well, we'll all be listed as inventors. It's not the same as collaborations. Interferences, who was the first to invent it? Ownership, the research agreements, the material transfer agreements. So who's, especially if you're working with, say, a cell line or gene products or things like that, who provided what materials at what points, and therefore how does the ownership get spread around. So most turn on who did what and when. So if you just watched the prior presentation on this general topic that discussed ownership of the research data, obviously, where all this type of information is written, signatures, well-written descriptions, and when, dates, and times become really, really important. So one final point on the patenting strategies. Develop a patent claim drafting strategy altogether. Select the types of claims to be made. Prioritize the goals for maximum protection. Include licensing safeguards. Analyze potential revenue flow. Carefully define field of use. Analyze the target infringers. Address all statutory hurdles. And so if this isn't making much sense to you, don't be too concerned. This presentation was a bit slanted toward talking to the administrators at UTSA, but they ended up inviting everyone, even the scientists. So when the presenter discussed this slide, she indicated that this is what your institution, if you're a researcher, this is what your institution should be taking care of, and you will get involved with it when you're going through this process. So now let's consider how we might get through a stage of getting from what we're most familiar with, the hypothesis-driven research and theories, all the way to something that could generate some cash. So from the idea to the cash. So there's the research institutions are dealing mostly with hypothesis and theory. So these types of activities are very commonly non-GLP or even not GLP. So the title, the term non-GLP really means it's very close, but it's not exact. Not GLP means something that's even farther from GLP. The good laboratory practice that I've mentioned in the prior presentation, and I'll tell you now that if you don't know what it is, you need to look into it to understand the rigor of everything that goes into that. And that definitely picks up with the discovery and early development going into the biotech. When you see this high red point here, that's definitely where GMP and GCP pick up and move forward toward commercialization. But typically it's the big pharma that will begin to pick things up from the biotech at the tail end, and the biotech, of course, is fed into to some degree by research institutions, including the public universities like UTSA. So many of the big pharma do not have as extensive R&D programs as they had in the past. They allow the biotech firms to generate things that will have the greatest promise for top dollar, buy it, incorporate it, further develop it if necessary, and take it all the way. But usually it's got to be through the FDA if it's in that category that would require FDA approval before they'll pick it up. So the big picture synergies exist and the great value can be created. So the big picture on perspectives, we have the research institution, the biotech, and the pharma, and we're considering stakeholders, concerns, goals, and objectives. So the stakeholders are different. You have taxpayers and the government and the research institutions. With the biotech, you've got early investors or venture capitalists, for example. The founders. In pharma, you have institutional investors and a board of directors. Many of the pharma, as you know, are publicly traded corporations, C-type corporations. The concerns that are present, many times it's the prestige with the research institutions, newsworthiness with the biotech companies so that you can get seen and bought out by pharma, or your product can be purchased by them to take it grand scale market. And of course the sustainable growth is the primary concern of pharma. Remember, patents have a 20-year life cycle, and so as big pharma's patents run out, they need new things to come in. That's a big part of substantial growth. The goals, you've got research institutions that want to attract and retain the top faculty. They want to achieve and sustain national ranking. In the biotech, you have survival and to validate the study so that it has the hope of reaching the market with the credibility and appropriately, legitimately. And then, of course, whether they can sustain it themselves or it passes on to fit into the realm of pharma to meet projections of their growth, right, sustainable growth, and the strength in the pipeline to draw from all sources internally if they have their own R&D and the biotech line, as we had said. The research institutions as objectives would seek endowments, research grants, the IPO or the market capitalists under the biotech. IPO is the public trading opportunities to get to that level, and the rapid growth. Pharma would increase their R&D and the productivity. The big picture now with cultures, we have real life, value, and assumptions. So under real life, the ivory towers, tenure, publish or perish. In biotech, there's a bit of hype, heroicism of the founders and everything, and then that IPO to get to the public trading, where you trade stocks that you create out of nothing other than some perceived value, and people buy it, and it generates cash to work with. The pharma has the blockbusters, the bureaucracy, and they're a slave to the street in a sense. The research, we have this expansion to knowledge, that's academia. Biotech is expansion of the market cap. Can you push your market ever bigger and bigger and bigger and find new markets? And then, of course, for pharma, they're already there, creating some of the caps that restrain the biotech in a sense, and they want to sustain an ever-expanding range of profits. The assumptions, quite a great deal of the risk is removed at the level of the research institution. The speed is subordinate, meaning it is at a more casual pace, even though it is still a hectic pace. You have to tend to your institutional commitments other than just the research. In the biotech, it's very focused, the risk is embraced, and speed is life. And then in pharma, risk is mitigated, and speed is important. So understanding who you are, negotiating with anyone that might be trying to give you some money to do some work. There are critical deal topics. We see here on the y-axis importance, and on the bottom publication rights, confidentiality, IP, and indemnification. And the blank is the research institution, the biotech, and the pharma, the same from the left to the right. So obviously publication is important in the research industry, research institutions, and a little less, about a third on this relative scale for the others, because the data is used more so to get things to market than it is just to get recognition for the scientific contribution. Confidentiality is a bit reversed, less IP focus in the research institutions, although it's growing, and it is, of course, top priority in the biotech and the pharma. You don't leak anything until you have the patent protection. Then it's public, but it's protected. As you'll see, you go to the Patent and Trade Office, you search, and you can find any patent that's pending or that is there. And so once it's there, it is protected, but also public. And then the indemnification is the same. Any problems come up, and you are liable to legal actions. So the typical points of the contention, the critical deal topics, intellectual property, publication, confidentiality, and the indemnification, as we saw. The IP concerns when working under contract with, say, a biotech company would contract for you to do some work or something like that. That's what this is about. So what would be the IP ownership in the end? So the original contractual agreement has to have some type of statements whether IP is expected or not. There should be something there. What if something pops up? Then who owns it? And then how does the inventorship become established? So all three entities that we've been considering, research institutions, biotech, and pharma, do agree that inventorship follows U.S. patent law. There is the rule that the creator owns the data, the IP. The exception is under the clinical trial agreement. And then the ownership follows the inventorship. So if there is contractual statements, you would expect these standard things to be there. If not, you need to get curious about the deviation and inquire as to why it is there. So how is inventorship determined? By definition, according to U.S. patent law, and of course it is different from authorship and collaboration. Since inventorship is statutorily defined and determined, an institution cannot decide in advance who is the inventor or who the inventor will be for IP resulting from the research. You have to see who comes up with the idea, the creative expression, and they have to have it documented that indeed it is theirs. Intellectual property should be treated the same for all agreements. Sponsored research agreement, material transfer agreement, clinical trial agreement. As we said, there's an exception of the standard clinical trial agreements that dissipate some of all of these to all the parties involved. Ideal IP clause for all agreements. What you invent is yours, what I invent is mine. What we invent together is jointly owned. Inventorship follows U.S. patent law. Ownership follows the inventorship. Money does not equal ownership. Why can't UTSA give unknown IP away to sponsor before it is created? Well, who owns the IP once it is created? The Board of Regents of the UT system. So this is what was mentioned in the prior lecture on who owns data. And we said at that time whether your data really is intellectual property in the sense of patenting or being patentable or not, the Board of Regents of the UT system owns it, or whatever institution you work for. If it's under a blanket institution as the UT Public Schools, UTSA, under the UT system, they own it. You will be the inventor if you invented it, but they own it. So use of state of Texas resources, the personnel and the equipment, adequate compensation for the intellectual property. How can that be determined if you don't know what the IP is? So if you don't know beforehand what's going to be invented, it's difficult to make any decisions on these matters. So there are some troublesome IP clauses. Non-exclusive royalty-free license. This is for internal research only. It would be good, but to make use and to sell and to sub-license something, this is a bad way to do it because you don't reserve, you don't exclude others from using it, you don't reserve any right to have to generate revenue and to charge somebody to license to use the property, the invention. If the sponsor wants to own our IP, your IP, it's our if you work for the public system, and not just a license, and then the background intellectual property, and then the right of first refusal. So these are some of the terms that if the UT System Office of General Counsel or any of the representatives see them, they would probably disapprove the contract. Non-exclusive royalty-free license in SRAs. These are sponsored research agreements as the SRAs. So the internal for research purposes only, as we said, it's acceptable, A-OK, non-conforming, it's non-transferable. Make sure the NERF comes with option to negotiate royalty-bearing, sub-licensable, exclusive license to make and use and sell, so long as there's some flexibility to rearrange it. Try to limit them to internal use only, avoiding language that gives sponsor right to commercialize your inventions for free. So these are some other things related to this that are not so important to us right here, but I'll leave them there for a moment if you want to read it over. Most of us would not be involved in this because this, as I said, is still related to the presentation of this attorney to the administrators at UTSA. So we wouldn't be involved with some of this. It's good to be aware of it so that if the institution expresses concerns, you would be able to understand or ask why, and when they replied, you would know, then you would be able to communicate however you were allowed under such situations with the potential sponsor so that you can not burn any bridges, I guess, in a sense. So this agreement allows a sponsor a worldwide perpetual royalty-free, fully paid-up, non-exclusive license, sub-licensable to anyone to make, use, and sell any invention created under the agreement. That's kind of odd. Form G, non-conforming provisions in an agreement. So I'm just going to go past these to get to some other things that don't apply so directly to administrators. So a little background on intellectual property. What is it? Stuff you own going into an agreement. Why would the sponsor want it? What should you do? Don't agree with the BIP, the background IP, or narrowly define it to one piece of intellectual property. So it is important, and it shouldn't be buried and lost easily to a sponsor. So problems with the background IP, what intellectual property is rumbling around in the background and being used, and is potential of being lost and abused in that sense. So what is the scope of it, to be able to identify it, to limit it to one principal investigator, try to control it, and then compare to the foreground intellectual property. So this interchange of recognizing intellectual property, its distinctions, its interplay, interdependencies, ownerships. Can one be clearly patented separate from another? These types of things are important in this arena. So the right of first refusal, what is it? It gives the holder the right to meet any other offer before the proposed contract is accepted. When the sponsor has a NERF, remember that acronym from before, the license, and does not exercise its option to negotiate an exclusive royalty-bearing license, and reserves the right for first refusal, just to be able to back out. So what does it mean? If you negotiate an exclusive royalty-bearing license with another company, before you sign the contract, you have to offer that deal to the sponsor. So when negotiating the intellectual property, you have to avoid troublesome clauses, avoid the pitfalls that NERF licenses to make, use, and sell, sub-licensing, ownership of IP, background IP, and the right for first refusal. So these non-conforming provisions, what happens to my agreement if it contains non-conforming provisions? How can an agreement get approved if it has non-conforming clauses in it? And the process agreement on Form G of a transmittal letter are some of the questions that you might ask within your institution. Well, what is this Form G agreement? It's a non-conforming agreement, IP, publication, or indemnification provisions, helps to weigh the benefits against risks. Do the benefits outweigh giving the IP away altogether? Identify non-conforming provisions in the agreement. The administrative approval procedural process of UTSA is essential. The UT system doesn't discourage or encourage these Form G agreements. They were created to fill a need. So these Form Gs are not discouraged. They're important to the administrative authority. For negotiating agreements, you can't negotiate out non-conforming provisions. You identify the deviations. The negotiator transmits the Form G that's actually getting into things that we don't need to discuss. But anyway, I appreciate your time and attention and letting me take you through this discussion. And it's in the context of the UT system, so if you stay within Texas, I hope that you find this useful in that way. Otherwise, I appreciate your time and attention. Oh, there's more on the publication concerns. Well, we'll just stop there.